you were indicating that you felt you had laid the proper predicate to allow the playing of the testimony that the child gave to Mr. Raley.
Yes, sir, Judge. Judge, in order for evidence to be admitted as past recollection recorded, the witness needs to state that they do not have a full and accurate memory of the event at the time they are testifying, and that they've previously given a statement, and that statement was true when the events were fresh in their mind or when they remembered things. In this case, AJ has admitted that he gave a statement to the police officers the day of this. He doesn't remember what he said, but he knows that he told the truth. In fact, he's indicated during his testimony he has seen this video, that he told the truth to the officers when he was telling them about these events. I provided, of course, the case of Kimbrough versus State, 846 Southern 2nd 630. In this case, a cite to the State v. Marcy case, and I provided you that. But in this case, the witness didn't indicate that the statement was made by him or it was accurate when he made the statement, and it was inadmissible hearsay. And the Florida, the 4th DCA here, talks about what is necessary in order for the statement to be admissible. And they reference State v. Marcy, where they talk about a tape-recorded statement of a domestic violence victim was admitted as past recollection recorded when the witness indicated that she had talked to the police and she would have tried to be truthful. You also have the Montano case, which is 846 Southern 2nd 677, again out of the 4th DCA. And this case stands for the proposition that you may use a tape recording as past recollection recording, and it is an exception to the hearsay. Again, what is over on page 3 of this opinion, Judge, the court cites that even though the declarant is available as a witness, a memorandum or record concerning a matter about which a witness once had knowledge but now has insufficient recollection to enable the witness to testify fully and accurately, shown to have been made by the witness when the matter was fresh in the witness's memory and to reflect that knowledge correctly. And this isn't just unique to Florida. This exception is recognized in the federal courts as well as the state courts. And I would submit that under the testimony that you've heard today, that we have laid the proper predicate that this statement, the recorded statement as well as the video statement that AJ gave to the police that afternoon at around 5 o'clock, which would have been roughly about 2.5 hours after the event occurred, although not a spontaneous statement or an excited utterance, does qualify as an exception to the hearsay rule. And there is no Crawford problems here, and I've cited the court the case Herrera versus Vega, 888 Southern 2nd 66, for that position. And in that case, the admission of a child's hearsay statements to parents regarding an abuse did not violate the confrontation clause. I realize, Judge, that when you're talking about this Herrera-Vega case, they're talking about 803.23, that exception, and we're dealing with 803.5, past recollection recording. But I would submit that there's no Crawford problem here, and we've laid the proper predicate for the admission of this statement.
Judge, the Court of Recollection talks about memorandums and records. It doesn't talk about out-of-court statements that are made as part of an investigation. If that were true, we'd be playing statements in all these trials because nobody remembers exactly all the details of what they told the police. Now, if I'm not mistaken, A.J. Hutto gave an account of what happened that day. It may be inconsistent with what he said in his statement, but he didn't say, I don't remember, and the only way I can remember is if I saw my statement I gave the police because that's what really happened. He remembered parts of it, he didn't remember parts of it. So I don't think you can just wholesale bring in an out-of-court hearsay statement and call it past recollection recorded when the witness testified and through leading questions gave a lot of answers to what happened. Now, when I crossed him, he gave different answers, but that's for the jury to determine, the credibility to give this account. And simply just bringing in a statement, well, this is what he said on August 8th as substantive evidence, I think it would be a violation not only of the hearsay rule, but the confrontation clause. And then my client wasn't there and I wasn't there, and we didn't get to ask him any questions. Those were solely posited by law enforcement who were investigating what they thought to be a homicide, and they were trying to elicit answers that would support the conclusion that they had already made, was that this was a homicide case. So I don't think it fits the definition of past recollection recorded, and even if it did, I don't think the proper predicate has been laid, because this witness didn't say, I don't remember anything about it, I got to rely on what I said back then. He remembered parts, he didn't remember parts. So unless we can tailor it to specific areas where he said, I don't remember, but what I told the cops is what really happened, I don't see any basis just to play a statement to the jury that was taken as part of an investigation.
With all due respect, Judge, I respect Mr. Smith's opinion and analysis of this. However, if you just look at the Montano case that I previously cited to the court, it addresses the very issues that Mr. Smith just brought up to you. And I'm referring to starting off with footnote 1 on page 3. Testimony about a recorded recollection derives whatever force it possesses from the fact that the memorandum is the record of a past recollection. And then it talks in this case about reduced to writing while there was an existing independent recollection. The reliability of a recorded recollection rests upon the veracity of a witness who is present and testifying. Now, Mr. Smith has had an opportunity to cross-examine at length the witness here today, and so the jury's had an opportunity to gauge his veracity. But it goes even further than that, and in this case, it specifically allows tape recordings to be admissible for past recollection recording. Footnote 2, although the exception to the hearsay rule developed with respect to written documents, Section 980, subsection 980.803, subsection 5, allows for tape recordings as recorded recollection. Most courts that have ruled on the issue permit tape recordings to be recorded recollection. Then down in footnote 3, most of the cases admitting tape recordings as recorded recollection do so upon the testimony of the person who gave the statement that the recording accurately reflected his knowledge at the time the statement was made. The position that the witness has to totally have an absence of memory is not supported by the Montano case or Professor Earhart in his book over on page, and I don't know if the court has a copy, I'll be glad to give you mine, Judge, but I'm citing under 803.5, page 82 of the 2007 edition, up at the top of the page, well, starting on the prior page, 871. In order for the contents of a writing or memorandum to be admissible under section 90.8035, it is not necessary that the witness's memory be totally exhausted. Section 90.803 subsection 5 provides that the exception applies when the witness has insufficient recollection to enable him to testify fully and accurately. If the witness has some memory of the fact but does not fully remember the incident, section 90.803 subsection 5 may apply. I think I would suggest to the court that's what we have in this case. The witness has a memory of some of the events that happened. For whatever reason, he chooses, either he has forgotten or he chooses not to remember. But on that day, on August the 8th of 2007, he remembered and he gave an accurate and detailed description of what happened, and I submit that we've laid an adequate foundation for the jury to hear that. Now, they don't get to take that back to the jury and take it back with them, but I submit that they do get to hear that under 803, Judge.
Judge, the issue is what he can't remember. Most of the questions he answered yes sir or no sir. There's very few I can't remember answers that A.J. Hutto gave. One of them was that he couldn't remember what his mom did after the drowning. Now, to the extent that this records what she did after the drowning, I would concede that that probably is past recollection recorded. But my objection is that just doesn't open the floodgates to play every statement he made during this investigation, which is all hearsay, when the issue is, did he say, I can't remember, and did he say, what I said on August 8th is an accurate reflection of what I saw, and therefore I would rely upon what I told the police. And in some ways he said that. He remembered talking to the police, although he didn't really remember talking to the woman down in Panama City. But to that extent, for instance, if they want to play the portion of the statement where he describes what his mother did after the drowning, then I would concede that's past recollection recorded. But to play the whole statement from beginning to end, I think would be an abuse of discretion in this case, because what that statement is rank hearsay. It fits the parameters of Crawford. It's testimonial. There's no confrontation rights afforded my client when that statement is played. We have no ability to cross-examine that statement, and we're going to let in a lot of information that's not past recollection recorded because he was able to give an account of what happened. So that's my objection. Unless they can tailor it to specific areas where he said, I can't remember, and oh, by the way, this statement reflects what I heard and saw that day, then we're just letting in a lot of hearsay.
All right, we're going to take a short break, and I will come back and announce my decision. I'm not going to turn the microphone on to make sure that the jurors do not hear this. After my review of the cases that have been provided to me, I do agree that certain portions of the interview with the officer will be admissible for the jury to hear. I think that the young man's testimony is sufficient for me to find that he recalled talking to the officer the day of the incident, and I believe his testimony was that he attempted to be truthful with the officer in the response. I think those criteria are necessary for me to determine that whether a prior recorded statement meets the criteria for past recollection recorded. And I can the record is clear as to his testimony in that regard. Then, having read a little bit further than Professor Earhart's work on evidence, and I have a different volume than the one the state referred to, but the wording was the same. One of the footnotes under 803.5, and it's under the paragraphs that you've asked, I believe that you read, or at least in my book. This is footnote number 6, and it begins with citing Golden versus State.
Yes, sir.
In the next column, it quotes a passage from, I believe it's Weinstein Evidence, section 803.501. And I'm reading from this. If the witness answers some questions without hesitation, then becomes vague or evasive or claims he cannot remember a particular aspect of the question, even after he's been shown a memorandum to refresh his recollection, memory. Disability should be determined on a question-by-question basis rather than by viewing the witness testimony as a whole. And it gives the example, for instance, if a witness remembers an incident such as an accident but has forgotten the details. As the line red green, the contents of the previous statement relating to traffic signals should be omitted, provided the other test are omitted. And if I understood Mr. Smith's argument correctly, that's in essence what he was arguing. That the young man was able to give answers on some questions that other areas he said, I don't remember or I can't recall. Those areas, I think, criteria has been satisfied that that portion of the tape can be heard by the jury. To do otherwise, I think would open up the avenue for whichever side of the past recorded statement to present not only those items that the witness could not remember, but also in presenting testimony consistent with what the witness presented to court, it would be an improper bolstering of that witness's testimony by presenting prior consistency. So, Mr. Baswell, I'm glad to hear the additional argument that you have to make.
Judge, I respect the court's ruling. However, in light of Mr. Smith's opening statement and the questions that he asked on direct examination, I would submit that he has opened the door for all of that to come in, because he got up there and said, we don't know what story he's going to tell today. You know, we know what he told back then, and then during his cross-examination, he made several points. Do you remember saying this? Do you remember saying that? Do you remember saying this? And most of those statements, when he started asking that, he said, no, I don't remember that. So I would submit to you that it would be admissible to rebut those charges of recent fabrication, Judge, as well as past recollection recording, based on what Mr. Smith said during his opening and especially during his cross-examination, Judge. I don't see the hearsay problem, since under the case law, the Florida case law, once he testifies that it would be proper. And I've read this right here, and I see the two cases here are cited in those other footnotes there, Kimbrough, and of course Montano is not cited, Judge.
So now you're suggesting I should allow it in for purposes of
Prior inconsistent statements.
No. The statement that he gave today on direct examination was pretty consistent with what he gave to law enforcement. It wasn't in as much detail, but it was consistent. Now, when Mr. Smith gets up there and starts asking him some of the other things, he said, no, I don't remember that, or he answered differently. And I would submit to you that it goes to show that he was consistent back then, Judge, with what he testified to. The statement that he gave on August the 8th, that wasn't initiated by law enforcement. The grandmother and the grandfather.
I understand that, but law enforcement's the one who's doing the question.
Yes, sir, that's true.
For the most part.
Yes, sir.
But you're suggesting now that the statement, that entire statement would be admissible to show that he's made a prior consistent statement?
Well, that he didn't just fabricate or fabulate this, I believe that's the word, confabulate, excuse me, that the defense has used before, and he used it during jury selection. He didn't confabulate this. This is what happened that day. He hasn't added to it, other than when Mr. Smith starts getting him confused with some words about drowning. Did she drown then or two times? And I'd submit he's got a trouble distinguishing drowning between dying, because they thought she was dead then and there. However, they got her and took her to the hospital, and she later died at the hospital. So I think, Judge, that I respectfully would request that the whole statement be played under the two positions that I'm advocating to the court.
Judge, if I may,
Yes.
This is a narrative here, so picking out the different portions, I mean, it was going to be a very difficult burden to redact those situations where he might have touched on something that he answered and then he said, I don't remember. And we've also got a situation, Judge, where opposing counsel went back over some areas that he might have answered to us and he said he doesn't remember under cross-examination. So I think I know the direction of the court's ruling. Of course, we disagree with it, but if you rule that, what do we do about situations where he might have remembered it on some questions and said he didn't remember the same situation on others?
And I can understand the court's concern with this, Judge, and I know that you're just trying to get at the truth like we all are here. However, the fact that he may not have as accurate memory today should not impair what his memory was then. He has testified. There is no hearsay problem because this is an exception. And they've had the opportunity to see his credibility both on direct examination as well on cross-examination. But his memory was better then. And for the jury to be able to see how he answered all of the questions then, and then be able to judge his truth and veracity and his memory that day, I submit is relevant, and it does not violate any hearsay rule here in Florida, and it doesn't violate any Crawford problem with the federal courts, Judge.
Well, I think we're confusing a lot of issues here. Number one, we're talking about past recollection recorded. We can go, and I've asked the court reporter to transcribe his testimony. We can go to the record and find the areas where he says, I don't know. And you can read them into the record. I mean, that's not very hard. You just stand up there and read them into the record. They apparently want to show the video of the child and all that. I understand that, and maybe it's unwieldy editing it, but the answer is, that's what you do. You just read the portions that are actually past recollection recorded where he couldn't recall. Now, my questioning of him on cross-examination was meant to elicit or to lay the predicate to bring in evidence of prior inconsistent statements. He testified to a certain set of facts here in the courtroom. Some he couldn't remember, but in a prior statement he could remember. So I can impeach his credibility not only by showing that he said something different than what he said in the courtroom, but he's saying he doesn't remember here in the courtroom, but back then he said something completely different. And that's a different inquiry. And that's the heart and soul of cross-examination, is to try to get at the truth by asking questions and setting a predicate to bring in another witness to say, well, no, that's not what he told me. Primarily, I was focused, as I kept talking about the woman down in Panama City. He gave a CPT interview after he was interviewed by the police. It was much more in-depth. Those people are much more skilled at doing interviews with young children. They got a wealth of information out of AJ that either didn't come from the stand today or is inconsistent with what came from the stand today. So I shouldn't be punished. I shouldn't be accused of opening the door by doing garden variety cross-examination. So I think we could adhere to the court's ruling by going to the transcript, getting the areas where he says he doesn't remember, and the state can offer those in by simply publishing the transcript. We don't need to see the video. We don't need to see him recite. He knows the different colors, and he knows those types of inquiries, which half of the interview is devoted to that sort of information.
Judge, I think Mr. Smith has made my point for me right here before the court. He wants to pick and choose and take just bits and pieces, and under the doctrine of completeness, you are not able to do that taking questions out of context. Now, there was not 10 minutes of what are your colors or anything. There is a page and a half where the officers are trying to establish that this young boy knows the truth and the difference between a truth and a lie, and then they get right into the interview, Judge. And to just pick and choose one question here where he didn't remember here and play that part or read that part is taking this out of context, and I think the jury would have a better understanding. It's taking it out of context to judge his truth and veracity here, as well as whether or not he could accurately relate those facts when they were in his mind 2.5 hours after this incident, Judge. And that's all I've got to say, Your Honor. Thank
All
you.
you got to say about that. Quote the famous line from
Yes, sir.
gentlemen, so with the understanding that my ruling will be I guess, finally announced after we conclude the testimony today, we will proceed with the taking of other testimony. Let's bring the jury back in.